clear description of what you might do if things do not go the way that you require or expect is important to you. And again, in terms of language, you can frame those rights in such a way that they are not simply a big stick. It is not simply, if you do this, we will stop funding you. We will stop providing that expertise. You can create language which allows for a negotiation, an ordered settlement, creates the basis for you to go and try to sort the problem. By, rather than saying we will take this action, we have the right to take this action. We may take this action. In commercial contracts, you are often looking straight at the big stick. You are often looking at stopping funding, withdrawing from the arrangement, suing for recovery of value, and whatever other steps might be available to you. When you're dealing with a counterparty who quite bluntly cannot survive without the help that you're providing, without the resource that you're providing, then that blunt remedy is not necessarily the one that you want to spell out in the arrangement that you come to. Foreign law risks, any transaction involving an overseas jurisdiction can throw up its own particular problems, unique local issues, some of which we touched on earlier. Questions of how you might go around, how you might actually go about signing a contract. Do they have local formalities? Are there local regulation issues? If you're confronted, and one came up over coffee, you know, if you're confronted by an official looking demand for your organisation to be registered in a particular jurisdiction at a particular extortionate cost, you know, some of the jurisdictions that you're dealing with can throw up their own particular problems. Some of it is possible to mitigate against some of the risks. And this is where we will come on to communication and trust piece. If you were to come to us and ask us for a quick bit of advice because you're interested in doing a particular transaction in Western Europe, we have a network of contacts because we're accustomed to doing projects in Western Europe. We have a network of contacts. And more often than not, members of that network will anticipate that they will get calls from us periodically asking for a quick steer on how you might go about doing this in Italy, how you might do this in France. Can you do this in the Czech Republic? And having a source of that type of general advice that you know and trust, that you can pick up the phone to or drop an email to without immediately thinking that the clock's going to be running at the far end and you're going to get a bit of advice and you're going to get an invoice 2 days later, is so important to any sort of international transaction. Expectations from your overseas partners. This is one of the questions of contractual equality, because your foreign partners' expectations will vary from project to project, country to country. They will have expectations of you. And one of the advantages of setting out any sort of written framework in which you're acting is that you can manage their expectations. And expectation management is something that is absolutely central to many of the corporate transactions that we're involved in on a daily basis, where one of the greatest frustrations through transactional legal work is often caused because somebody has told somebody else that this can all be done by tomorrow afternoon. When in fact what they should have been saying was, we can look at it this by tomorrow afternoon. We're going to instruct our lawyers. We'll come back to you when we know how much time is needed to do this. We should be doing this by then, we should be doing that by then, and we should aim to have the whole lot completed at the end of next month.
Works.
Yes, quite. Expectation management is one of, or lack of proper expectation management is one of the easiest ways to create an incredible amount of frustration. And it is something that is dealt with so easily by having that early communication on the right terms. How often do your clients get upset about things not being done exactly in lines with what somebody else has told them? It's all the time. All the time. And if somebody says, yes, we'll have that by tomorrow, they expect it tomorrow. And if you set off on a business relationship on that sort of footing, and on day one you've said, day one, we'll have this to you tomorrow, and on day one it's not with them tomorrow, that forms and colours the course of your future dealings often. Is contractual equality possible? I think that in your sector, your aim is to work with rather than to provide to. And that sets a framework and creates a dynamic where really you are aiming to work often in partnership with recipient bodies. And that probably means that you start a discussion or want to run a discussion without giving the impression that you're the guys with the funds and the big stick. And we touched on this also over coffee, that to some extent you can dress up terms of any agreement so that they look soft in terms of the language. So rather than having things with memorandum of agreement that look terribly legal, or partnership contract which look terribly legal, you can water these things down so that it looks a more friendly approach than the types of commercial contracts that would be involved in the development of this site or the acquisition of the company. But that's it's not quite sleight of hand. It is simply setting a friendly-looking framework in which you're working. But at the end of the day, even with the most altruistic aims, you are not working on an equal footing. You know, you are the people with the funds or the expertise. And I think it's an admirable aim to try to set up a working framework in which the relationship looks unlike a commercial funding stick type relationship, and looks like a partnership relationship, but you go into these on the basis that you're the guys who have the purse strings. So to some extent, contractual equality is an aspiration, but not one that's borne out by the economic reality.